The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, this is Heather Jones, a Wisconsin family law attorney with O'Flaherty Law. And today we're going to do a how-to video for filling out a proposed marital settlement without minor children. This is a video that is for educational purposes only, and it is not legal advice. I'm going to say, and the form even restates this for me, that if you don't understand this completely and agree with it wholeheartedly, you might want to speak to an experienced Wisconsin family law attorney prior to signing off and filing this with the court, because this form is going to contain decisions that could affect you for the rest of your life. So it's important that you enter into it very cautiously and with a great deal of pre-consideration before signing off on this form. It is a proposed marital settlement, so that doesn't mean that every aspect of it will be entered into the final order, but the court will want to take your wishes into consideration, especially because there are no minor children involved. So it might be best to just treat it as a document that is going to be with you for the rest of your life, as opposed to just a proposed document. But that's just an opinion. If you're a joint petitioner for divorce and you and your soon-to-be ex-spouse have filed together and have already decided how everything needs to be divvied up and there aren't that many complexities involved, then this is a handy form to use. Again, it's Form FA 4153V, the Proposed Marital Settlement Without Minor Children, and we'll just start at the top of the document. So up here and on every following page in the top left-hand corner, you're going to put your name and your spouse's name for easy identification purposes, and in case anything gets lost or misplaced, they'll know it goes with your case. The top right-hand corner of the document is intentionally left blank. That is where the clerk of courts will file stamp the document. Don't put anything there. Don't staple anything. Just leave it untouched. If you're filling out a proposed marital settlement, you already have the name of the county that you're filing in, so you're going to file in the same county that your petition for divorce is in, or for legal separation, because this form also works for that. So you're going to need to clarify which case code it will go under, and then you should already have a case number as well, which you would enter right here, and then the names of the two parties, sticking with whatever identification you've had throughout the divorce or legal separation. Again, another warning, this time in the form. Subject to court approval, the terms of this proposal may be included in your judgment of divorce or legal separation. Be sure you understand it completely. Some portions of this proposal cannot be changed after the court approves it, even if you did not understand or expect how it would affect you. You may wish to speak with a lawyer before you sign this proposal to be sure that you are fully aware of the laws that may apply to you. Again, one more warning. If you're not 100% certain on every single detail included in this form, you should at least meet with an attorney to discuss it with you, because there could be long-term consequences that you don't know about related to signing this form and filing it with the courts. So an ounce of prevention is worth a pound of cure. All right, we're done with the warnings. I'm not going to warn you anymore. We'll go through the terms of the form and how to correctly fill them out. So I request that the court grant the following, and it starts with 1, the marital relationship. Divorce. The only reason for divorce in Wisconsin, a no-fault state, is that the marriage is irretrievably broken. Or 2, legal separation. And we have other how-to videos on our channel discussing the differences between divorce and legal separation and how they're very different. A legal separation is not a divorce, and if you get a legal separation, you are still, for instance, on the hook for debts that your spouse acquires because you're still legally married in the eyes of the court, and any debts or assets obtained during the legal separation could still be considered marital. And as far as a reason for legal separation, people have a multitude of reasons. Sometimes they're religious, sometimes they're financial. Just clearly and honestly state your reason. And if this line is not enough, you can just put "see attached" and put your reasoning on a separate sheet of paper. Do not alter the form. Just put it on a separate sheet of paper, explain to the court what's going on so that the court understands the context, and that should cover that requirement for the form. Moving on to Section B, spousal support. So, spousal support is often referred to as maintenance. They're interchangeable in Wisconsin. Paragraphs 1 and 2 are opposite sides of the coin. One party either agrees to give up the right to receive maintenance and understands that by giving it up at this time, you can't go back and ask for maintenance. You can't say, wait a minute, I didn't realize how expensive it would be to make it on my own, and my spouse makes a great deal of money, and I make nothing, and I should have asked for support and I want it now. If you waive your right to receive maintenance in this proposed marital settlement agreement and it's signed, you don't get another kick at the can. This is your one shot. I always think you should just ask for maintenance just to preserve your right to ask for it. But that's just my opinion. And if you just are adamant that you don't want maintenance and that you're never going to need it, then you can go ahead and waive it if that's what you think is the right choice for you at this time. However, you can say you're not requesting maintenance, but you want to leave it open. That could be tough to get the other party to agree to. They do put in some options here to see if the circumstances, you can give the court a particular set of circumstances, or say that, generally if there's an appropriate substantial change in circumstances. This is all very situation dependent. That would be something that you and your soon-to-be ex-spouse would need to discuss at length. And if you need more room to lay out what circumstances under which you agree that you could ask for maintenance, you can put it on a separate sheet of paper and just hit "see attached" on this line. Or you have the option to say, yes, my soon-to-be ex-spouse is going to pay me maintenance. It's going to be this much per month. It's going to start on this date, and it will end on this date. Or if the other party remarries, dies, or by court order, whichever comes first. So really, it's entirely up to you whether or not you want to waive the right, preserve the right if a particular set of circumstances should occur, or if you want to pay maintenance, and you will provide the court with specificity as to the amount, when it will start, and when it will stop. So you will go through all of the same questions and answers for the other party, just being very specific. And again, if you don't have enough room to lay out what particular set of circumstances would have to occur in order for one of the parties to pay maintenance to the other, you would just put it on a separate sheet of paper and write "see attached" on this line. But whatever you do, please don't alter the form. These forms are formatted in a very specific way to make them acceptable to the Wisconsin e-filing system. So while you can do separate sheets of paper, you can't add lines or change the margins in any way. So just don't alter the form. Use a separate sheet of paper to explain if you need more room. That's perfectly fine. If maintenance is going to be made, you need to articulate in the form how they're going to be made. So of course you can say no payments are ordered. Payments could be made to the Wisconsin Support Collections Trust Fund, which is a great way to handle it. This way, the party who is ordered to pay will pay the trust fund, and the trust fund will turn around and pay the payee party. And doing it this way creates an independent record of payments made and received, so that if at some point in the future somebody claims a payment hasn't been made, there's a record with the trust fund that can be accessed and used in your defense. Now, if the payer is self-employed, they can pay the trust fund directly, or this is always a handy way to do it, income assignment. So just have the payment directly pulled out of the payer's paycheck, and you would need to supply the name of the employer, the contact information for the payroll office of that employer, and that way it would just automatically be deducted, say every 2 weeks from a paycheck, and you don't have to worry about much. One caveat though, if the employer screws up and doesn't deduct the proper amount from the payroll check, it is on the payer to identify and correct the mistake. So if you have agreed to pay maintenance and you've agreed to have it automatically deducted from your biweekly payroll check, it is incumbent upon you to review your wage and earnings statement and make sure that the appropriate amount is being taken out. And if you see that it's not, you need to take it up with your payroll department, and you need to create a record that you identify the problem and try to deal with it. Because if you don't, if it just flies by you, you could be on the hook for maintenance arrears, back maintenance, and that's just not a place you want to be. So it is your responsibility to make sure that if the state trust fund is taking money out of your payroll check every month, you need to make sure it's the right amount. Again, with the top left-hand corner, the names of both the parties. Speaking of arrearages for previously ordered maintenance, Section 4 will deal with if there's any back maintenance owed. So you can always just say no maintenance was previously ordered, there's nothing due, or that it's all been paid, there's nothing due. Or option C, if there are any arrearages for maintenance now or at the time of the final hearing, those arrearages are waived and the court financial record shall be set at 0. This is just something, maybe you went to mediation and worked it out and decided, you know what, we'll just start fresh. You don't have to pay the arrearages, but we'll have the court record set at 0, and you can just start paying on the date that we agreed on up above. Option D, as currently reflected in the Wisconsin SCTF Kids Computer System, and shall be paid through the monthly income withholding by the Support Collections Trust Fund in the amount of X beginning on this date. The arrears balance shall earn interest at a rate of, it's usually between 1 and 6% per year until the arrearages are paid in full. So if there was a previous order to pay maintenance and you had to make the payments either directly or through your payroll check to the Support Collection Trust Fund, and you've decided that you're going to have that other spouse, your spouse, pay the arrearages, you can determine a repayment amount in addition to paying the regularly owed maintenance, and you can agree on an interest rate until it's paid in full. Or you can say the arrears shall be set at a flat rate. Again, this document usually either comes out of formal or informal mediation. So it could be that you just agree to like a lump sum payment or a lump sum amount, and then you could do a lump sum payment through the Support Collections Trust Fund, give the date for it, or you can agree to monthly income withholding by the Support Collections Trust Fund and give it an amount and a time it will start and an interest rate. Or, because this can be a little complicated and really, really tough to get to an agreement on, either formally or informally, you can just leave it up to the court. Say, let the court determine it at the time of the final hearing. But there's definitely a lot of options here. I mean, there's definitely a lot of room to work something out with the other party. Moving on to Section C, medical insurance. No later than the date of the final hearing, each party shall notify the other party in writing of the availability of COBRA or other continuation benefits under their current health care policy. So usually both spouses are on one policy, and if that policy offers COBRA or another continuation benefit to a spouse who's leaving the policy, you need to provide that information. I mean, that's pretty standard, but you do need to do it in writing. And again, if you sign this agreement, you're agreeing to do this. So if you don't agree, you could get into some trouble down the line. Just do the legwork, inform the other party in writing of what their options are under the current healthcare policy. Moving on to Section D is the personal property division. So this is where you propose how the personal property is divided, and you just list the items and then who gets them, just a quick X. So household items, your cars, life insurance policy, business interests, securities, pension, retirement, 401k, profit sharing, etc., savings and checking accounts, other personal property. Now, they don't give you a lot of room here to list everything. I mean, usually there's usually at least 5 to 10 bigger household items, 2 cars, at least 1 life insurance policy. There could be multiple business interests, multiple securities, and multiple pensions, retirement accounts. If this isn't enough room, as we discussed earlier, you can put it on a separate sheet of paper and just say what it is, say who gets it, and then you would just click See Attached and just attach that paper to your proposed settlement agreement. The next section deals with exchanging the personal property. So sometimes, if one party is living in the marital home and all the big stuff like the TV or computers, things of that nature are still there with that party, and the two of you have decided that, joint petitioner B is going to go out and find their own apartment, but they're going to get the big screen TV. Then you would list the items, and you can always put it on a separate sheet of paper, and then you need to give a deadline. I mean, it's helpful for everyone involved to give a deadline on when you're going to do this. And then you can also put in how you're going to do it. It could be they'll come over and pick it up. It could be, you'll agree to leave the house for 4 hours in an afternoon, and they'll come and get what the two of you agreed that they would get, although I don't know that I would necessarily recommend that. But there some kind of details regarding how the exchange will happen. What you're going to exchange, the deadline to exchange, and how to exchange. Now, if you've already done all that, then you just click None. And there's a little issue down here that you should be aware of. Any item of personal property not listed above shall be awarded to the party who has possession at the time of the final hearing. So if there's something you want, you better make sure it's included in this proposed agreement, because you should approach this agreement like it's going to be set in stone and you're not going to be able to come back later and start asking for your Green Bay Packers commemorative crock pot that you got from your grandmother or something of that nature. So now that personal property has been dealt with, then the court wants to look at the division of real estate. Usually it's just a marital home. Sometimes the parties will own more than one property together, like a cottage up north or a lake house. So you just need to tell your court what you have and what you don't have. So you can always say, we don't have any real estate at this time, and that's fine. That takes care of that. Or you can say one or both parties own real estate at this time. Now, first you will address your primary residence, and you will need the parcel identification number, the tax key number, and you will also need to attach a legal description of the property. Ideally, you should already have that with whatever paperwork you have regarding the ownership of your home, but it's relatively easy to find if you don't have it, never had it, misplaced it, whatnot. But they really want you to attach a legal description of the property. And that's so that it can be included in the order and to avoid any confusion in the future about where the primary residence is actually located and how it's identified. So you've told the court that you own real estate and you've clearly and legally identified the real estate. Now you're going to say who gets it, who gets the marital home. And the kicker here is that if there's still a mortgage on the home or a home equity line of credit, you're saying that the party shall be responsible for outstanding financial obligations and the other party shall be held harmless from any liability. Other provisions including refinancing requirements, if any, and then you're probably going to need more than one line, and you're going to have to click See Attached and put it on a separate sheet of paper. A lot of the time, people agree to refinance the home post-divorce so that only one party's name is on the mortgage. Section 2, this residence shall be placed on the market for sale. A lot of the times, parties just want to sell the marital home, and that's just fine. And you just put down who's going to stay there or take care of it while the sale is pending, who's going to pay for it while the sale is pending, and it can be either party, it can be shared equally, or you could come up with some kind of equitable division as far as the two of you are concerned. It could be a 70-30 split, whatever numbers you two have come to agree upon. Finally, pending the sale, any necessary repairs, special assessments, or other sale-related expenses shall be paid by, and then again, one of the parties, both of the parties, or some other kind of split that the two of you are comfortable with. Once the house sells, you need to decide how you're going to divide the proceeds. So the money from the sale of this residence shall be used to pay the usual costs of the sale and prorations and any balance on the existing mortgage. Upon payment of all costs, the proceeds left from the sale shall be divided between the parties as follows, And then here is where the two of you put whatever division of the proceeds you've agreed upon. Just as long as these two numbers equal 100%. Down here is a section for other real estate. One or both of the parties own additional real estate, including any timeshare interests, which is disclosed and divided as set forth in the attached Schedule A. So if you have more than just your primary residence, you have a vacation home or a timeshare, you're going to get a sheet of paper. You're going to call it Schedule A at the top, and you're going to list them, and you're going to list how they're going to be divided. And it would also be helpful if you talked about things like if you're going to sell it, if you're going to keep it, if it's going to be sold, who's going to pay the mortgage, taxes, insurance, repairs, special assessments. All of the questions up here could be reapplied to any additional property. So finishing up on the issue of real property, the form wants to talk about transfer of title. This proposed marital settlement alone will not transfer title to one party or the other, but such a transfer requires a fully executed quitclaim deed and a Wisconsin real estate transfer return signed by the parties. The party awarded a parcel of real estate shall be responsible for having the necessary documents prepared. And if they're real estate savvy, I guess they could do them themselves, or you could always ask an attorney to help you with the quitclaim deed and the Wisconsin real estate transfer return. Section F deals with marital debts and liabilities. So the following is a listing of all the debts and liabilities we presently owe, both individually and as a couple, and who I propose shall be responsible for the payment of each debt. So they've got some kind of general categories for you here: mortgage, car, student loans, personal loans, loans other, and credit cards. If you run out of room, you can always continue the list on an attached sheet of paper, but you have to list the creditor, how much is due, payment to the creditor every month usually, who's going to pay it, or if the two of you are just going to equally share it until it's paid. It's really important, just as a common sense note, it's really, really important to fully flesh all of this out. If you miss something and the final order is entered, you're going to have a tough time getting the other party to agree to additional things probably. I would just generally warn, just every single possible debt, pull your credit reports prior to doing this, go over them with a fine-tooth comb, be very sure that every debt is listed, pay for a credit report if you have to. Just make sure that anything with your name on it is addressed in this division of marital debts and liabilities. You just don't want something to pop up and bite you 2 to 3 years down the line after you've got your divorce. So after they have you list your debts and liabilities, you have to tell the court that you understand a certain set of facts here. 1, each party assigned a debt shall be fully responsible for that obligation and shall not make any demands upon the other party concerning the debt. So if you agree to it here, you can't turn around in a year and a half and say, I just can't handle paying this debt, can you pay it? You're in it for the long run. Any debt not listed shall be the responsibility of the party who incurred the debt. So even if it's not technically your full responsibility, if you incurred the debt, even though you incurred it during marriage, you could be cutting yourself out of an equitable division of a debt, of a marital debt. So just Like I said, be very, very careful. Pull your credit report. Make sure that you know about anything and everything under your name. Creditors are not bound by this proposal, and both parties remain liable to creditors for all marital debts. Any party who suffers a loss because of a failure of the other party to pay an assigned debt may enforce that obligation by motion or an order to show cause for contempt. So if you agree here in this proposed marital settlement agreement to pay for a debt, and then you don't, and it goes to collections, and next thing you know, they're filing in small claims against you and your ex-spouse because it's a marital debt, you can turn around and ask the court for relief because your ex-spouse was supposed to pay it. Section G is equalization of marital property division. So if one party gets, say, physically more than the other party, the party who got physically more may be required or could just pay cash to the other party to equalize the division. So let's go through this. No payment is required to be made to equalize the marital property division because A, the property and debt division are equalized to the satisfaction of the party, or B, equalization has been accomplished through a division of real estate sale proceeds. So that might be why you're telling the court you don't need anything equalized in your division. Otherwise, the two of you will agree to a payment of X amount that is required to equalize the marital property division. This payment shall be made by the petitioner to respondent or respondent to petitioner. You could also say that this payment has already been made or shall be made in a lump sum payment no later than, and again, here's your deadline, or you could do installment payments until paid in full. If you do installment payments or lump sum payments, you can agree on an interest rate on that until it's paid in full, and you can go from the date of the final hearing, or you can do from the date the payment was due. And that means if somebody was supposed to do a lump sum payment or begin installment payments on a certain date and they didn't, this is your safety net here. They were supposed to pay, they agreed to pay, they didn't pay, so we're going to charge interest, and these are the two possible dates you could charge interest from. Section H deals with taxes. So the year of your divorce or legal separation, you agree that the parties shall file their income tax returns for the year of the divorce, legal separation, consistent with the rules of the IRS, the Wisconsin Department of Revenue, and Wisconsin's marital property law. The parties understand that their marital status on the last day of the year determines their filing status for that year, whether married or single. The parties acknowledge that each are responsible for seeking tax advice from a tax professional with regard to issues of this divorce legal separation. So if you got divorced in the middle of the fiscal year and you're single on the last day of the year, I would take all of your financial documents and your marital separation agreement that's been ratified by the court into your CPA or your tax preparer and just let them know about deadlines and timelines and things of that nature so that they can properly prepare your taxes so that they'd be in conformance with the marital settlement agreement. In the years before divorce or legal separation, you could say tax returns for all previous years were filed, or sometimes people run behind, so they still have to file, say they haven't filed their 2020 tax return yet, and they were married for the entire year of 2020, they got divorced, say, midway through 2021, they still have to, and they got an extension, they still have to file for 2020 as a married couple. And this just puts into writing terms and deadlines for that preparation, because you don't want to be left on the hook if you were married in 2020 and you're divorced in the middle of 2021 and your ex-spouse won't cooperate with getting the taxes filed, which would be crazy, but divorce is a crazy time for a lot of people. This is just you articulating to the court that you will file returns for 2020 as an example. And you can either share the expenses and liability equally, or you can come up with some other arrangement within the law. And if it won't fit on this line, you can just write it up on a separate sheet of paper and tell the court to see attached right here. Section I is the legal name restoration. So you can either just keep your married name, or you can ask the court to return you to your former legal surname, your last name, whatever last name you had before you got married. However, note, if this is an action for legal separation, the court cannot allow either party to resume a former legal surname unless and until the judgment is converted to a divorce. As we discussed earlier in the video, a legal separation is not a divorce. You can't take your old last name. Section J deals with other proposals. So you say you understand that any oral agreements are not enforceable by the court. So say you and your soon-to-be ex-spouse have been like, yeah, I'll give you $500 a month in maintenance. But there's no writing and they haven't done it yet, so there's really nothing showing that oral agreement took place. Here you just say other proposals. I understand that any other oral agreements are not enforceable by the court. So 1, I have no other proposals, written or oral, concerning this marriage. Or 2, I have additional written proposals concerning this marriage, copies of which are attached. So if there's more here that isn't covered in the form, this would be where you would say that, and you would write it up on a separate sheet of paper, check box number 2, and let the court have a look at it. Section K, again, it's another warning, but it's called understandings. So I understand I could get an attorney to review this proposal. I fibbed when I said I wasn't going to bring it up again. This proposed settlement agreement contains decisions that can affect you for the rest of your life. This is where you tell the court that you understand that you could get an attorney to review this proposal and you've just chosen not to. This form was provided as a convenience and may not cover all issues. So it's really difficult to put together a reasonable form that would cover all potential issues in any particular set of circumstances for somebody's divorce. This proposal may have tax consequences, and that seeking tax advice is suggested. So if you take on a great big pile of debt, or if you take all the real property, it's gonna concern you tax-wise, and you should probably talk to a tax professional. I have fully disclosed my income, debts, assets, and liabilities to each other. So again, like when we talked about dividing the debts and liabilities, it's really important that everything be very well fleshed out and no stone left unturned, because you don't want to submit this agreement and have it approved and then realize, a year later that you forgot something pretty significant that could cause a lot of problems for either party entering into the marital settlement agreement. Any court order regarding the division of property is final as of the date of the final hearing and can never be changed. One shot, division of property, division of real personal property and real property. It's final. So, as I've been saying, just be very, very sure. Give it a lot of thought before you agree to enter into it. You also understand that there are certain legal presumptions under Wisconsin law, such as marital property should be divided 50-50. So basically, this is just the form asking you do understand that we're a community property state. Section L is the voluntary execution in nature of proposal. I assume responsibility for the entire content of this proposal. I have made this proposal freely and voluntarily and not because of any undue influence. I believe the terms to be fair and reasonable under the circumstances. I acknowledge that there may be substantial legal and tax implications with regard to this proposal. Again, this agreement could contain terms that will affect you for the rest of your life. I understand that lack of knowledge of the law may not be sufficient to convince the court that relief from these provisions is required. I acknowledge that I have the right to seek the advice of my own personal attorney. Yes, I always recommend that. Jumped forward. I got so excited when I saw the word attorney. So Section M, general release. The parties are released from any claim of any nature that may exist. Neither party may at any time sue the other personal representatives and assigns for the purpose of enforcing any or all of the rights relinquished and or waived under this proposal. In the event any suit shall be commenced, this release, when pleaded, shall constitute a complete defense to any such claim or suit so instituted by the other party. I understand that this general release shall not become effective until this proposed marital settlement is approved by the court. So again, if you agree to this, you're releasing any future claims, and if you plead this release, it's a complete defense to any such claim. Like if you come back later and you're like, oh, I'm going to sue you because you could have paid me more maintenance and you didn't, you agreed in the proposed marital settlement to pay a certain amount of maintenance, and that's what makes it a complete defense to any potential claim about maintenance you might make. Hopefully that makes sense. It sounds a little circular. So, full disclosure and reliance, I warrant that I have provided an accurate, complete, and current disclosure of all income, assets, debts, and liabilities. I understand that deliberate failure to provide a complete disclosure constitutes perjury under Section 767.127 of the Wisconsin State Statutes and is a fraud upon the court. The property referred to in this proposal represents all the property in which either party has any interest. This proposal is based on my financial disclosure statement. You probably already filed your financial disclosure statement with the court. Hopefully everything included in this proposed marital settlement agreement is congruent with all the information you gave in your financial disclosure statement. And again, anything you got and anything you spent during the marriage is a marital debt or asset, and you're required to fully disclose it to the court so that it can be properly and accurately divided. And if you lied to the court, you're guilty of perjury. Restraining order. Neither party may interfere with the personal liberty of the other or go to the premises occupied by the other as a residence except with permission of that party. I think that pretty much speaks for itself. Execution of documents now or in the future on demand. The parties shall execute and deliver any and all documents that may be necessary to carry out the terms and conditions of this proposal. For example, getting your late taxes filed or the sale of the marital residence. Divesting of property rights. The parties give up all rights to property awarded to the other except as otherwise provided for in this proposal. All property awarded to a party shall be the separate property of that party. The parties shall have the right to manage our separate property as if they had never been married. Survival of proposal after judgment. The provisions of this proposal shall survive any subsequent judgment of divorce and shall have independent legal significance. This proposal is a legally binding contract entered into for good and valuable consideration. It is contemplated that in the future either party may enforce this proposal in this or any other court of competent jurisdiction. Again, be very careful before you agree to this. Entering into this agreement can affect you for the rest of your life. Jurisdiction. This county shall have jurisdiction for all disputes unless otherwise agreed to in writing or as provided under the Wisconsin state statutes. Approval of court required. I submit this proposal to the court for approval and request the court incorporate its terms in the final judgment. Once approved by the court, I understand that either of us may enforce this proposal in this or any other court of competent jurisdiction. Waiver of appearance. The court may proceed with the final hearing without further notice and consent to judgment being entered on the petition pursuant to the terms of this proposed marital settlement, even if the respondent or one of the joint petitioners does not appear, because you've basically hashed it all out already. This is not a sworn document. It does not need to be notarized, but both parties need to sign, print their names, give their address, their email address, and their contact info. And then if you had an attorney fill it out for you, they would just put their state bar number there. So here's Schedule A, the division of other real estate. And we already talked about this. Just make sure that you have, this is not the primary residence, this is any other real estate that you own during the marriage. You want to make sure you have the parcel ID number and the legal description of the property, and it just goes through just how you decided to divide up your primary residence. All the same questions. You would just go through the video, if necessary, explaining how you're going to handle the award of the property, the pending sale, costs of the sale, and costs of maintaining the property while you're waiting for sale. So that is all she wrote as far as the Proposed Marital Settlement Agreement without minor children, otherwise known as Form FA-4153V. Again, this is a very significant document, and if you don't have many marital debts or assets, then this could work for you. But if you have, I guess, what could be considered a large and complex marital estate, you certainly should probably meet with an attorney to discuss long-term consequences of the proposed division before you sign and agree to the settlement agreement. And even if you're amicable with your spouse and it's a joint petition, you still may want to go off and have a quiet chat with an experienced family law attorney about signing this proposed form. But regardless of, if you'd like to learn more about divorce in Wisconsin, you can always visit our page. It's linked below. And be sure to leave any questions you have in the comments section and subscribe for more legal content daily from us. Thank you so much for watching, and best wishes for your future success.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience, and we serve all of Wisconsin. Thanks again for watching.